conference. Would like to make a motion.
Oh, I'm sorry. I apologize. Yes, sir. I'm sorry. Yes, sir. I'm not prohibiting anyone. Yes, sir. Yes, sir.
Your Honor, just respectfully, now that the state has closed its case, we would like to renew our motion for a directed verdict on all the grounds we previously raised. I will not repeat all the oral arguments we previously made, just like the record to reflect that it has in fact been renewed. I would like to bring your attention, Your Honor, only to 2 points. The first is that...
You're not limited. You can bring up as many points as you want.
I don't want to waste the Court's time repeating everything we said previously, but there are 2 things I think that are very clear and would be important to assess at this time. The evidentiary rule for perjury cases requires the testimony of at least 2 witnesses to establish the falsity of a fact. In this case, the state had confirmed in our previous argument that with respect to the charge that Andrea Sneiderman lied when she said that she did not know prior to her arrival at Dunwoody Prep that Rusty Sneiderman had been shot. The sole evidence that the state has on that issue, on that charge, is the testimony of Donald Sneiderman. It is uncorroborated by anything. There is no other evidence submitted in this record that establishes that knowledge prior to the arrival at Dunwoody Prep. As a matter of law, the Court has to rule on that issue before it submits it to the jury. We respectfully submit there is no such corroboration and that charge should clearly be dismissed.
And you're speaking only to count 4 for right now?
I'm speaking, I believe it's count 9, Your Honor. It's the perjury charge on the same issue.
Well count, yes, sir, the perjury count.
That allegation effectively arises in 2 places. They've made a false statement count with respect to it. They have made a perjury count with respect to basically the same thing.
Right. Count 4 is a perjury count. That's why I was
Is it? Then I apologize, Your Honor. I didn't bring up the indictment.
I was just making sure we're on the same page.
Yes, sir. That would be the count.
Now, count 9, because I know the numbers change. You may want to take a look at your indictment.
Yes, sir.
I shouldn't say they changed, but because certain counts were dismissed. Count 9 is a perjury pertaining to wit that she did not share a hotel room with Henry Newman in Longmont, Colorado, such statement being material to the issues surrounding the murder of Russell Sneiderman. Now, count 4 is a perjury count pertaining to wit that she did not have knowledge that Russell Sneiderman had been shot at the time she spoke with Donald Sneiderman prior to her arrival at Dunwoody Prep, such statement being material to the issues surrounding the murder of Russell Sneiderman. That was count 4.
Yes, sir. I'm talking about count 4.
Okay.
Yes, sir. And under the new indictment, or the renumbered indictment after the previous charges were dismissed, I'm talking about count 4, the perjury charge on that issue.
Yes, sir. That's what I was saying.
Yes, sir.
And you had another point?
The same thing applies to the count that references the alleged kiss in Greenville, South Carolina. And that is would be now count 12, Your Honor.
Yes, sir. I have count 12 marked also.
There is no testimony in the record establishing whether or not that kiss took place in Greenville, South Carolina, other than the evidence of the oral testimony of Christine Oliveira, the waitress. In the absence of corroboration of that kiss, as a matter of law, that is insufficient to go to the jury. Okay. Your Honor, I'd like just the record to reflect that, plus that we've renewed our motion for directed verdict on the same grounds that we previously argued, sir.
Who's going to address this issue?
I will, Your Honor.
All right, Ms. Krause, if you could specifically address the issues
I will, Your Honor. I will, Your Honor. I think that is just to say that there are 2 witnesses required to corroborate a charge of perjury is just a misstatement of the law. 2 witnesses are not required. The 1 witness is not sufficient. However, there has to be corroboration, and corroboration can take the form of a 2nd witness, or corroboration can take the form of any other circumstantial or direct evidence tending to prove the count. Count 4, the reference to Donald Sneiderman. Donald Sneiderman testified in a direct way about his conversation with Andrea Sneiderman, and that would provide a basis for count 4, the count of perjury. In corroboration of Donald Snyder's testimony was the phone records indicating that at the time the phone call was made, first of all, it established that a call was made, established the duration of the call, it established the location of the defendant's phone when she made that call, and it was prior to the time that she arrived at the daycare and could have been told that her husband had been shot. So those corroborating circumstances corroborate the testimony of a single witness, and I'll refer the case to the Dixon, I'll refer the court to the Dixon case that we discussed when this topic came up during the directed verdict motion. The sufficiency of the corroboration is an issue for the jury to determine. There's certainly enough to provide the state with a sufficient basis to get it past the directed verdict. We've done that. The court's already ruled on it, and there's no reason, the defense gives this court no reason to change that ruling. The second charge that is...
Count 12.
Thank you. Count 12, yes, the perjury. That the defendant lied on the stand under oath when she testified that she did not kiss Hemi Lumen while in Greenville, South Carolina. The testimony of Christina Oliveira was that, in fact, she witnessed this event. The corroborating circumstances surrounding that were the receipt indicating that Hemi Newman and Andrea Sneiderman were at that restaurant on that day, the cell phone records that corroborate Ms. Oliveira's account that during the period of time when the defendant was in her restaurant or her bar, her dance club, that she received a call and became upset. There are phone records that corroborate the fact that the defendant received or made a call to Rusty Sneiderman during the time period that Ms. Oliveira testified that they were in the restaurant. She's identified the defendant as being there. She's identified Hemi Newman as being there. And the email communication between the defendant and Hemi Newman in the days after the second Greenville, South Carolina trip corroborate that, in fact, something happened that made the defendant feel angry, upset. She had desire versus reality, conflicting feelings, things like that tend to corroborate the testimony of Christina Oliveira. For those reasons, the state has made, as a matter of law, a sufficient showing that those 2 counts of perjury, as well as all the other counts in the indictment, should go to the jury, and we'd ask the court to deny the defense motion.
Anything else, Mr. Chalmers?
Respond briefly to both.
Oh, you may.
On the first point, the law does in fact clearly state in the evidence code that when a conviction is sought to be premised for perjury on the oral testimony of a witness, it must be corroborated by independent, strongly corroborative evidence. In this case, the state is bootstrapping. They're essentially arguing that the corroboration of what Donald Sneiderman said, Andrea Sneiderman said, is the fact that the phone call occurred and the phone records show that it occurred. That is not evidence corroborating his assertion of what was said. Remember, the 2-witness rule goes to the alleged falsity of the statement. In order to prove that Andrea Sneiderman lied about what was said in that phone call, they have to come up with 2 witnesses to prove that, or 1 witness, which they have, Donald Sneiderman, plus corroborating evidence. There is no corroboration in this record of what occurred in that phone call. The cases are very clear. You may not convict somebody for perjury based on oral testimony versus oral testimony. That's all we have here. With respect to the second issue about the kiss, the law is very clear that the corroborating evidence must be independent of the testifying witness. The records that were introduced from the Pulse restaurant came from Christina Oliveira. She participated in preparing those records. That is not independent corroboration of her testimony that a kiss occurred. It must be independent. Case law is very clear of that. In addition, the fact that the records show that they were there does not show that there was a kiss. In this case, the state has alleged that the defendant lied about whether there was a kiss. This is what we've spent our summer on. That issue has to be corroborated by some other testimony. There is no email that references a kiss. There is no testimony of another witness saying, yes, in fact, there was a kiss. As a matter of law, on those 2 counts, the state has failed to meet its burden of proof, Your Honor. Thanks, sir.
Mr. Chalmers and Ms. Cross, at this point in time, I'm going to deny the motion for the directed verdict as to count 4 and 12, and saying that there may be slight corroboration, but the jury's going to make the ultimate decision. So both counts 12 and 4 will continue to go forward at this point in time. Exceptions noted. Mr. Clegg, you needed something else for the record before we did the charge conference?
Can't say that I do, sir, no. I'm unaware of what it is that I need to place on the record. No, sir, I do not believe there's anything else I need to place on the record.
All right, that's fine then. Let's complete the charge conference. Lawyers, what was discussed yesterday evening, that was an initial interaction and conversation pertaining to the proposed request for charges. Yesterday, we started with Mr. Petrie and Ms. Cross, and or anyone else wants to interact. I had indicated what was going to be provided. There was a couple items on the, we're going to start with the state, Mr. Petrie, and you'll respond first, followed by Ms. Cross. On number 10, requests, Mr. Petrie, it was the evidence charge. It is meant to be tailored specifically for this particular case, Mr. Petrie. Any particular language you're objecting to, Mr. Petrie?
And you're talking about the state's request?
Yes, I'm at states.
Oh, I'm
because,
sorry.
because I'm looking for your objections, because I know they want it because they filed it. And states number 10. I put a question mark by it.
Right.
Now, since all the evidence has concluded, it does need to be tailored specifically for this one. And when I say tailored, I mean, obviously there's proposed language that state is submitted in parentheses, or I can just do it this way. Ms. Cross, since these are your submissions, let's just start with you. You want me to put, go ahead, Ms.
Which
Petrie.
we are, the second full paragraph, the one that starts character for truthfulness.
That's correct.
I don't believe that there's been any testimony for or against any witness on their character for truthfulness.
Ms. Cross?
I agree with that, Your
I
Honor.
agree. So, Ms. Jeffries, that would not be lack of bias toward a party. You want that included?
Yes, sir, I believe
All
that
right.
that would
I
be.
think that is,
So it'd be the first paragraph and the third paragraph, Ms. Jeffries. All right, that was on number 10. I had hold on number 11. That was the old impeachment of witness intact. Are you still pursuing this, Ms. Cross?
I think the only relevant paragraph, Your Honor, would be the first and then the bias toward a party.
I would agree.
All right, so first, the second paragraph, Ms. Jeffries, will not be given. The language that has been deleted at the bottom has been removed, so to be given with that modification. I had a hold on number 13, prior statements. Is the state still wishing this one?
Yes, Your Honor, I believe that there were several witnesses who were either impeached or attempted to be impeached by prior statements.
Ms. Petrie?
I believe that's appropriate.
All right, will give, 13. I had a question mark on 15, the intent. I was going to give the first and second, I'm going to use the term paragraphs, but it's a line in the second paragraph. The issue was the third paragraph. What's the state's position?
I think that's a correct statement of the law, and it should be given, Your Honor.
Ms. Petrie?
Your Honor, that is a correct, now, sit down while I address the board, if that's okay, so I can continue looking at it, we prefer me to stand, Your
I
Honor.
prefer for you to stand.
I will be happy to stand.
Thank
I'm going to
you.
stand right now. Your Honor, that is a correct statement of the law, but as requested by the state here, I believe that the caveat that some statutes require a specific intent needs to be given with it. This is correct as far as it goes, but does not apply to all of the counts in this indictment.
Well, let me do this, Mr. Petrie. I know you have some specific requests on that. What about when I get to yours? What I would do is give the general quote-unquote intent as requested, and then identify those counts in the indictment for general intent, and then also identify the counts that require specific intent.
That would be absolutely appropriate.
Okay. Can we even now, lawyers, there are 13 counts, because that way we're on the same page, because no one want to be surprised. Mr. Pete, well, either side, Ms. Cross or Mr. Petrie, as far as on the general intent, what is the state's position on which counts do you want the general intent to relate to? Because I want to simply say, as it relates to counts X, Y, and Z, I'm not going to say general intent, but the intent will be given.
Right.
I think the only specific intent charge is going to be the hindering.
Which is number 1.
Your Honor, for specific intent with respect to each of these statutes, and they are included in our pattern jury instruction, not pattern in the jury instructions, the rest of the charge that we submit.
Right.
Frankly,
Go ahead. I'm listening.
on the perjury, and I think it was from the state's request that the false statement must be made with the intent to mislead.
Right.
That is a specific intent.
Correct.
So I believe on all the perjury counts it would be appropriate. On the false statement, you have to intentionally make a false statement.
Correct.
It's not just making a statement that is false, so I believe it would apply to that as well.
Correct.
On the hindering, by definition of the statute, it applies to certain parts of it. Now, there are, the complicating factor and the confusing part of this to me, Your Honor, is there are certain acts in each of the counts that just require the general intent.
That's correct.
But there are other parts that require the specific. I would simply ask the court, and I think as long as the court instructs the jury that certain counts require, as I will instruct you, a specific intent as defined by that statute, and then you will give that statute, I believe that should
Would that satisfy you?
That would satisfy us.
Would that satisfy you?
Yes, sir.
All right.
So we're talking about adding a line to what is state's request to charge number 15, saying certain counts require a specific intent, I will define the specific intent to those charges when I define those charges.
That is probably the cleanest way to get it to the jury.
All right, and we'll do it that way. What I do, Ms. Jeffries, will craft that and let both sides look at that prior to 1 o'clock.
Yes, sir.
Make sure everyone's on the exact same page.
Thank you.
All right. I believe, Ms. Cross, that's the last one in yours that we were holding on. There's no
Your
here.
Honor, we actually have some additional objections with respect to the states. With 2 of them I've mentioned with Mrs. Cross earlier. They are numbers 26 and number 27 of the state's instructions. The 26 and 27 are 2 attempts to cite the elements of a violation of 16-10-20. They recite the statute correctly. At the end, one says a person shall be guilty of concealment of facts. That's number 27. At the end of number 26, it says shall be guilty of the offense of false statements. The statute alleges different subsections, and they're not spelled out with A, B, or 1, 2, 3 in the beginning. But for example, on number 26, the state's request to charge, it ends by saying that the person shall be guilty of the offense of false statements. That is the second subsection, and what we need to delete there is everything after the word willfully up until the semicolon. So what would be proper is if we were to say a person who knowingly and willfully makes a false, fictitious, or fraudulent statement, etc. That's correct, but where it says falsifies, conceals, or cover up by any trick, scheme, or device of material fact, that goes to a concealment allegation, which is covered by the state's request to charge number 27.
So on 26, you want to read false statements in matters within the jurisdiction of the state or political subdivisions. A person who knowingly and willfully falsifies, conceals, or covers up, period.
No.
No, sir. It would read a person who knowingly and willfully, and then it would eliminate everything there until the word makes.
What's the state's position? Because they were basically just eliminating the word falsifies, conceals, or covers up by any trick, scheme, or device, a material fact. What's the
That
state-
goes to the
I
concealment.
understand.
Just count it up.
What's the state's position?
That's the way to charge.
You see the modification, Ms. Cross?
I do, Your Honor. Yes, Your Honor, we don't have an objection to that.
So it's going to read a person who knowingly and willfully
Makes it false.
makes, hold on, wait a minute. So willfully, there we go. Let's delete that language and we come all the way down to makes a false, fictitious, or you just want false only?
No, sir. Basically what we're doing is we're deleting everything between the word false, between the word willfully and the semicolon.
Correct.
So we're going to start with,
No, I understand that. We're there. Then it says makes a false, fictitious, or fraudulent statement or representation.
yes, sir, that stays.
Right. Correct. That's what I was reading. That's fine. In any matter within the jurisdiction of any department or agency of state government or the government of any county, city, or political subdivision of this state shall, be guilty of the offense of false statements.
Yes, sir.
All right. Is that consistent?
Yes, Your Honor.
No, you got that, Ms. Jeffries? All right. Now,
Same thing with respect, I'm sorry.
no, go ahead.
The same thing applies with respect to number 27, Your Honor, except we're deleting the alternate language. So this one ends with the thought of be guilty of the offense of concealment of facts. And so therefore, everything on the second line after the semicolon, after the word fact, should be deleted. So makes a false, fictitious, or fraudulent statement or representation.
All that should be deleted.
Yes, sir.
Correct. And it will read, concealment of facts, matters within jurisdiction of state or political subdivisions, a person who knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a material fact. The language deleted comes down to any manner within the jurisdiction of any department or agency of state government or of the government of any county, city, or political subdivision of this state shall, be guilty of the offense of concealment of facts. State agrees?
No objection.
All right. That'll be modified.
Thank you, Your Honor.
Anything, now we were holding on, well, I was holding on because we didn't know whether your client was going to testify.
Right.
She decided not to testify, so any objection 28?
I don't think it's necessary, Your Honor.
So you withdrawn.
I'm withdrawing,
No, you're right to withdraw it. That's all I need to hear. Withdrawn. Because the defendant did not testify. Okay, number 29. Did you say you had any other exceptions you want to put on the record?
No, sir.
Okay, so that's all of the states.
Not the states.
Okay. Is there any additional state request for charge?
no, Your Honor.
Wonderful. All right, let's turn our attention, Mr. Jeffries, to the defense question charge. We're holding on, and Mr. Petrie, if you could, which one, the first one we're holding on yours to come back to, we had 49, and we've gone through the majority.
Right, and I was doing
The
it.
first one I had is number 12. I was holding on 12.
Right. That's covered by one of the states, number 12, defense rule 12.
Defense 12, any objection,
We-
Ms. Cross? I think it's covered already.
We've covered this, and we've already made modifications to their request, so we will withdraw this one,
Okay,
Your Honor.
their 12 was withdrawn. Okay, and number 13, we're just gonna give that, for 13, the last paragraph says the credibility of the witness may be
Right.
attacked by disproven facts to which the witness testified. Let's see. I was holding on 17, defense 17,
We do request this.
and the state has no objection, because
No
she did not
objection.
testify.
Yes,
And now the language that's gonna be listed here, the defendant in a criminal case may take the stand and testify and be examined and cross-examined by any other witness.
Is that what you want?
No,
No, you-
that's not what we want.
You don't want that one, do you,
No.
Mr. Petrie? Okay, so you don't want that paragraph?
No,
Mr.
sir.
Petrie? Okay. So you just want the last paragraph, Mr. Petrie?
And, right, and last paragraph, scratch out however.
That's correct. I was gonna say, okay. So this, so Mr. Petrie, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision.
Yes, sir.
Any objection from the state?
Yes, sir.
Wonderful. With that modification of deleting however, we'll give Ms. Jeffries on 17? All right. Number 18, Mr. Petrie, this is yours. It says good character of defendant.
I don't think we actually had technically
Technically,
good
you don't have
character.
good character witness.
I think we had
I understand, but you didn't,
habit and routine. I saw.
correct, you didn't have.
Let me
quote,
confirm.
unquote,
Mr. Clay's called out.
Well, he's outside working on his closing, but,
I do not
You're
believe that
you're
is
gonna withdraw?
appropriate. Yes, sir.
all right. If it's withdrawn, 18 is withdrawn, and I'm assuming the state has no objection when he withdraws.
Would you not, Your Honor?
21, this is what you did have.
Yes, sir.
Any objection to 20? That's why I was holding on, because we had not got to that point.
I do object to that, Your Honor. I don't think there's a basis in it.
Let me consider that. I'm sorry, say that again? You say you objecting because what? I heard what you
There's any
said.
evidence of habit, routine practice.
I think we had lots of that, Your Honor.
I'm gonna give, yeah, I understand what you're saying, but from an interpretation standpoint, I'm gonna have to give that one. We'll give overstate's objection, Mr. Jeffries. So 21, we'll give. Let's see, 23 would not give, wait, I don't know, let me go back to the ones I was calling on. Had a question mark on 27. This one you want?
Interject if we're going to go ahead to the other ones, because count 24, like the record to reflect, the defense does in fact want 24 in.
No, I know, I mean, I put all that, I mean, that's been noted, I mean, I'm not giving it. Mr. Petrie laid the, he put his objections on.
I just want to be clear, I thought that John might have said yesterday, Mr. Speaker, that we were okay with not including that as long as it's included elsewhere. I don't believe it is included elsewhere. It is an element of the defense, and I want to make sure that the record reflects that the defense requests that be charged.
Okay, we're not give, it's noted. All right, now, Mr. Petrie represented your side very well. Number 27. What's it, you said, this is one, Ms. Cross, you want me to come back to?
This is,
Defense 27.
Defense 27. Yes, Your Honor, I didn't think
You
that
mentioned it late yesterday afternoon, and I told you we'll come back to it.
we did, and I can't remember now why.
So, does that mean you have no objection? That's all I need to hear.
No, I do object to that, Your Honor, for the original reason, not the second reason I came back to it. I do because I don't think that is, one of the charges is concealing facts, and I think that silence or non-disclosure is not an affirmative act. I think that is contrary to the case law. I think that would not be, it's not tailored to the facts of the indictment in this case.
Your Honor, I respectfully disagree with that. It is actually supported by the case law. There is a Fifth Circuit case, 1977, the United States versus London case, which very clearly states that mere non-disclosure is not an affirmative act. It is not a trick, scheme, or device for purpose of the federal concealment statute. That was subsequently cited and relied upon by the United States Supreme Court in the Woodward decision, also interpreting the federal false statement and concealment statute. There are Georgia cases,
Yeah,
including
I don't mean to catch up, but the way it was working, Mr. Petrie was representing, I was listening to one lawyer at a time. Now, I understand you guys can work in concert, but actually, no offense, but are y'all handing off, who's representing the defense on these issues? Mr. Petrie or Mr. Chalmers? I just want to know who I'm listening to.
You want to?
Sorry.
If the court would like to just hear from one of us, I will defer to Mr. Chalmers from here on out.
Okay.
That's what I'm inferring that from the court. You won't want us to choose.
Correct. Yes, sir.
Your Honor, there are just a couple of the charges where I'm prepared to testify based on the legal authority on what happened yesterday. With respect to charge 27, the request is that the charge silence is not an affirmative act be included. The London case and the Woodward case have been included.
Let me respond this way. I will give over state's objection unless you want to talk me out of it.
I have nothing further to add, Your Honor.
I mean, that's what I was trying to see what I'm listening to. I was going to give it, but so, okay, I will give over state's objection. We'll give, Ms. Jeffries. I just had a question mark because I want to hear from both sides.
Thank you, Your Honor.
All right. Are there any other question marks? And I know, Mr. Chalmers, for whatever reason, you were not here yesterday afternoon, and we've gone through all of these, and there was only some exceptions that I had put question marks about it. I want to hear from the lawyers.
I don't have any other that.
I don't have anything else. And the idea was, and I don't want to limit you, but that's why we spent an hour here yesterday afternoon.
Your Honor, I understand, and I have very little else. The one case, Your Honor, if it's helpful to have additional citations in support of it, charge number 38.
Charge number 38. Let me go back to 38.
That the corroboration must be strongly corroborative. I watched the testimony. I watched the hearing last night, Your Honor, and the state objected, stating that that was not an accurate summary of the law. This is the interest of CH case, Georgia Court of Appeals, August 2003. That is the relevant quotation down highlighted there, which states the corroboration for a perjury conviction must be strongly corroborative. It cites back to a 1909 case, which establishes this has been the law in Georgia for over 100 years, was reiterated in 2003. So I'm happy to give the case to Your Honor.
Oh, I'm happy to have it.
May I approach you?
You may.
On the second page.
And I said, I'm just looking at, is this the last one we're dealing with?
Yes, sir.
All right. What's the state's position?
Your Honor, I maintain that while there is some language in that case law, there is language in the other case, Dixon, West, I believe, is the other one that is, excuse me, is contrary to it. And so the wording that we have agreed and is going to be submitted with no objection covers the topic of the corroboration necessary. The jury will be informed in the pattern instruction that generally the testimony of a single witness is sufficient. In cases of perjury, some corroboration is necessary. That's accurate, that's complete. The charges, as we've agreed to be given, covers the topic, and the state continues to object to defense request number 38.
I'm going to take a look at your recent case, Counselor.
Yes, sir. I do have a copy, Your Honor, of the case I'm citing, Dixon versus the state.
Well, you may, I thought you gave it to me already, but if you want to bring it up again, bring it up.
I did.
Let me take a look at it.
Just for recency.
Because I understand, I mean, the distinction is, I mean, the language he wants, and I understand, The corroborative testimony must be strongly corroborative of the testimony of the other witnesses. It must be such a character that when taken in connection with all other testimony, the falsity of the testimony is established beyond reasonable doubt. No, I understand. Let me see what you have. Thank you.
Your Honor, when you're ready, if I may address Dixon very briefly.
You may.
Your Honor, Dixon doesn't say anything contradicting the case that I gave to you. Dixon's also an older case than In Re CH, which is 2003. Dixon's 1984. All that Dixon says is that a conviction for perjury requires either testimony of two witnesses or that of one witness in corroborating circumstances to support it. That's just a recitation to the statute. The proof that the defendant had made contradictory statements is not alone sufficient to convict. We actually have relied on that principle with respect to a number of the counts. Moreover, in perjury cases, when we speak of corroborative evidence, we do not mean evidence that emanates from the mouth of the defendant himself. That's effectively stating the same principle. I believe that the portion of the language of Dixon that the state is relying on here is that the determination of the weight and sufficiency of the corroboration is a matter for the jury. Every element is always a matter for the jury. But in the previous cases, since 1909, and the more recent case after Dixon, which is the In Re CH case, the court made it clear the corroboration must be strongly corroborative in order to convict somebody for perjury. So we respectfully suggest that Dixon is not contrary to the authority that we gave to you, Judge.
All right. Well, I understand, Mr. Chalmers, as I indicated last night, I understand you had reviewed apparently the tape. I'm going to stand by my ruling. I will not give, and exceptions noted, and obviously yes, I understand, it's noted.
Thank you,
Judge.
Judge.
I will not give as indicated last night, and thank you for the supplemental cases. Any additional requests for charge meeting review?
Not from the defense, Your Honor.
Not from the state, Your Honor.
All right. One quick thing. Mr. Jeffries has given me a note. Look back at, Mr. Chalmers now, the state's request number 6, because it needs to be tailored to this particular case, on Mr. Petrie, who started last night. What deletion, because this is on a stipulated facts law.
Yes, Your Honor.
It says the parties have entered into a stipulation that has been approved by the court about the following, because I know there was Mr. Chalmers, I know you're involved also, but there was a written stipulation, lawyers were going to have it drafted.
I think each of those items were in some way stipulated to throughout the trial. There was the testimony of Mr. Kirschenbaum, there was the phone records and the exhibits, as well as the emails and the authenticity of some. So I think it's covered by facts, testimony, documents, and exhibits.
Exactly.
So it should be approved by the court about the following: facts, testimony, documents, and exhibits.
Yes, sir.
It normally wants me to specify, so
I think it might streamline it if we just mention here any stipulation, like the stipulation about Mr. Kirschenbaum, that doesn't go back with
Correct.
the jury.
Correct.
It doesn't.
And the records that we stipulated to, they would go back.
That's my belief.
BlackBerry would go back.
correct.
That's fine.
I think really that
There were several DVDs and other tapes that
just the
would go
authenticity.
back.
Right, correct.
So insofar as what this request to charge would cover, I mean, you really want it?
Do I really want this?
Yeah.
Well,
Is that gonna?
well, first of all, you got stipulated facts, so you're going to have some version of it, because
They need to know what to do with it. Yeah.
Fact we had, I think, it was Mr. Kirschenbaum.
correct, but
Well,
you
there
don't want them to disregard things that you. Well, I'm not telling you what to do, but
Right.
you really don't, so you really want this, well, I know you asked her, she didn't respond, but you want some version of this.
The state requests the charge be given.
All I need is, what do you want in the, for the lack of looking at the list, that's all I'm asking. Because I don't want it to sound as if I'm making a comment on any particular thing. I'd be more than happy just to say the parties have been into a stipulation that has been approved by the court about the following facts, testimony, documents, and exhibits, and don't say anything else, if that's what you want.
We could even do just certain facts, testimony.
Right.
But it really requires me to specify which ones they are. That's
Yeah.
what I was going to get to.
Okay, I mean, we have a written stipulation that I think we're happy to add Mr. Kirschenbaum's testimony to, and that, from the state's perspective, is sufficient.
Right.
Okay.
And you had one other thing you wanted us to sign. There was a simple one that we've gotten. But
You had the phone records?
So
We'll
that
talk
list-
over,
right,
yeah.
But actually, we need to do it now because when we come, because the lawyers technically
Right.
have to know what's going to be given before they give their closing arguments.
I mean, we stipulated two.
you brought in the second one that you. Now,
Yeah.
You may.
get some of this stuff. Did you have a stipulation?
Like I say, now, if both sides agree, if you don't want me to specify what those are, I don't mind, as long as everybody
Yeah,
understands. it's
if
gonna
he
be-
agrees, I'm okay with it.
Hmm?
If the defense agrees, I'm okay with that.
I'm fine with that too.
All right.
Okay.
Sure, because I think everything that was stipulated to was identified at the time. It was just sort of certain facts, testimony.
So the word we're adding, Ms. Jeffries, is
You think we should?
following certain facts, testimony, documents, and exhibits, period, and then I will read the rest of that body. All right, and the other issue was on number 11, States 11. When everybody's free to stay, we're just going through, this is what a charge conference looks and sounds like. Please repeat what was okay. On number 11, just want to make sure we're on the same page. We got the first paragraph.
With the exception of the,
The second paragraph would not be given.
in the first paragraph, the parenthetical phrase would not be given.
Correct, will not be given. Correct. And then the second paragraph will not be given at all. The third paragraph, bias toward a party shown by bad acts, extrinsic evidence of cross-examination, specific instances of conduct of the witness in question that may relate to the witnesses in question is biased toward a party. I'll just read it in its entirety, and nothing else will be given. Okay? So now, those only questions Ms. Jeffries had, any other, just want to make sure we're on the same page. So see, once we break, we're going to be back at 1 o'clock.
Don't say, did Ms. Jeffries understand that what we're requesting is in the first paragraph, that parenthetical charge only those that apply be withdrawn because there is only one in this case?
Correct. You follow Ms. Jeffries?
Yeah.
If I'm not,
Okay. On number 11.
About certain testimony.
Okay? You may want to say it out loud so Ms. Cross can hear and make sure we're on the same page.
scratch through, charge only those that apply.
Gotcha.
Right. That won't be given, Ms. Cross, and this is on your request.
I
So it'll
think
be the
that's
first
correct.
paragraph with the exception of what's in the parentheses, and then this third paragraph down. I would not read the code section, but all the other information.
Yes, sir.
Okay.
We're in agreement.
Okay. Anything else? I see,
Yes, sir.
because we're going to, you sure?
You sure? Mm-hmm. You sure? Mm-hmm. Okay. Yes, Your Honor.
Okay. Mr. Chalmers or Mr. Morgan, anything on the charge? Anything else we need? Mr. Chalmers? I don't want to leave you out.
Your Honor, the only thing I would note is that the jury instructions will now state that silence is not an affirmative act, but it does not link up that with the trick, scheme, or device requirement, because charge number 31 requested by the defense is not going to be given. The trick, scheme, or device language, Your Honor, is straight from the statute. The Marcus case holds that a trick, scheme, or device must be an affirmative act. The instruction that silence is not an affirmative act is, in fact, what is now going in because it is the law.
But I'm giving you number 27.
Number 27.
I said I will give.
I think
It
that,
says silence or non-disclosure is not in print record. That's what you want me to, I said I was gonna give that.
yes, sir, but in order to link it up, silence or disclosure is not an affirmative act. We have to explain to the jury why an affirmative act is relevant. The charge that does that is number 31.
State renews its objection to charge number 27.
No, I understand, it's noted. But I was gonna give 27, but I said I'm not giving you 30. Yes, I understand, Mr. Jones.
Okay, thank you, Your Honor. Nothing further from...
All right. Anything else for the record?
No, sir.
All right, Deputy Garrett, we will be on recess until 1 o'clock, lawyers. And if you could, I know your lawyers are doing closings, if y'all please update them on what will and will not be given, please.
We will do that, Judge.
All right, thank you.
All rise. Anna, we're being paged.
So here we are. We are making our way now toward the end of this. As you look at Andrea Sneiderman, the lunch break is forthcoming. I'm Jeff Hullinger, along with Zara Karinchak, who is with us. She is a former federal prosecutor, a defense attorney, a graduate of the Air Force Academy in Colorado Springs, Colorado. She has led an amazing life, and we appreciate